Is affirmative action racist to whites and Asians? Stay tuned and find out right after this.
That Corbin and Corbett legal team fighting for the rights of the people. That father-daughter team investing in the youth when the system ain't treating them equal. Providing truth for our people, we able to reach them. So anytime you get accused for a crime and Lord knows you ain't do it, we here to get you through it. Exemplifying prudence and glorifying God, making sure you're compensated for other people's doings. Our vision is to be one of the best. We're small enough to focus on your matter throughout the neighborhoods of Dallas. Working constantly and making sure your rights are protected. A firm team of lawyers, aggressive, effective. A team that has your back in the courtroom. Two well-spoken black lawyers in the courtroom. Investing time and resources when it's evident that you were treated wrong. Now you walking out of Dallas courtroom with a settlement. Corbin and Corbett, the father-daughter legal tag team that has your back in the courtroom. Our purpose is simple: to obtain the favorable outcome for each client and glorify Christ in all we do. Our vision is to be one of the best and most...
Hey guys, what's up? This is attorney Chloe Corbett, aka the Duchess of Justice, and with me I have
Attorney Augustus Corbett, a.k.a. the Minister of Justice.
we are the Defiant Lawyers. We provide legal analysis of trending politics, policies, personalities, and pop culture to empower you to defy an unjust legal system. Before we get into today's topic, before we get into today's very controversial topic, please go ahead and like that like this video, hit that subscribe button, and share this video to your family and friends so that they too can be a part of the legal rebel community. With that, Dad, happy Saturday, and how are you doing today?
Happy Saturday to you as well, Chloe, and I am doing well. I am grateful to be alive and healthy and blessed, and so I have no complaints. What about yourself?
I am the same. I'm happy to be alive, always blessed, always thriving. In the words of Charlemagne, blessed, black, and beautiful. So hey,
I love it.
I have no complaints here. But today's topic is today is a big one. Today is a big one. And the question for today is affirmative action racist to whites and Asians? There's a lot of chatter around this topic. Um, Affirmative action and differing opinions on affirmative action have been percolating throughout our society for years and years now. And the reason that we're bringing this up today and we chose this topic for today is because the United States Supreme Court, they decided to hear arguments from two cases involving affirmative action later this year in 2022. And we wanted to getting here, doing an analysis of where we think the court is going, especially because there's a 6-3 supermajority of conservatives on the court, and go into the history of affirmative action policies and legislation in this country. But while we're up here, we're live, so we want to hear opinions from our legal rebel community. So anyone who's watching, comment down below. Do you feel like affirmative action is racist to whites and Asians? Do you believe that colleges should consider race as a factor in admissions? We want to hear from you. We want to get a lively but respectful debate going on. So let's get into these two cases that are going to be the oral arguments are going to be heard in front of the Supreme Court later this year. The first case is called Students for Fair Admissions versus the President and Fellows of Harvard College. Okay. So the students for fair admissions is the plaintiff, and they are suing Harvard College for what they call reverse discrimination on its affirmative action policies and the way that they admit their students, Harvard College. And I want to get into a little of the backstory of what Students for Fair Admissions is, and then we're going to get into the history of affirmative action later, and then we're going to address the question that the petitioners filed in this case. So, Students for Fair Admissions is an organization which, according to them, they seek to recruit students who have been rejected by selective universities, and they file lawsuits on their behalf. So it's a nonprofit organization that will go out and recruit students who have been rejected by these selective universities, and they connect them with attorneys and they file lawsuits on their behalf. And this man right here, he is the founder of SFFA. His name is Edward Blum. He is a conservative. He is a conservative legal strategist. He is a conservative failed politician. He ran for office here in Texas and lost, and that kind of started his foray into this into race issues, where he filed a lawsuit in the Supreme Court, kind of going after gerrymandering, which he won. He was involved with the voting rights, with a huge case involving voting rights legislation, Shelby County v. Holder, which Dad, you've analyzed a lot. So he has gotten into this space, and he is seen as, one of the sole leaders of someone who says that race should not be involved, with higher admissions, with voting, etc. And what he did was, with the Shelby County v. Holder case, he went out and he lobbied, officials in Shelby County, and he was the major reason for those officials bringing the lawsuit against then Attorney General Eric Holder. And with that, the Supreme Court gutted the Voting Rights Act. It struck out a huge section of the Voting Rights Act, Section 4 of the Voting Rights Act, which gave the federal government the power to scrutinize states when they change their voting methodology. And that section was put in the Voting Rights Act because a lot of states, as we know, used various methods to keep Black and brown people from being able to vote. And Section 4 was a protection for these minority voters. It was a pre-clearance, where if a state wanted to change their voting policies, they would have to get pre-clearance from the federal government, and the federal government would scrutinize it. But with the Shelby County v. Holder case, Section 4 was gutted, and now states have been given even more leeway to put in place racist and discriminatory voting measures. And we covered a lot of that in our last topic last week, last Saturday. So he was involved in that. He was a major reason for that case. He was also involved in the Abigail Fisher v. UT Austin case. I'm sure a lot of you all have heard about that, but Abigail Fisher, she was a white student. She applied for UT Austin. She was rejected, and she sued UT in federal court. And again, he connected with Abigail Fisher. He bankrolled that lawsuit. He put Abigail Fisher in touch with attorneys who would represent her. His company lobbied on her behalf. So his organization, excuse me, has been the leading voice against affirmative action and not using race neutral approaches, or excuse me, of using race neutral approaches with college admissions. So he is kind of like the um I would say the boogeyman, kind of behind the scenes,
That's a
and
good description.
yeah, and bringing these lawsuits against affirmative action. So Dad, I want to before we analyze these upcoming cases, I want to give our audience a history of affirmative action, what it is, and a legal analysis of how the Supreme Court has approached the policy of affirmative action.
Okay, very good. And before we do that, thank you for laying it out the way you did and giving us some context, and letting us know what it is we're talking about today.
Yeah.
So, yeah, I want to, since I'm the old dude up here, I want to.
Age ain't nothing but a number.
Okay. So I guess it's because of my age, because of my numbers, then I guess it falls on me to try to go back and give some history to this issue of affirmative action. So let me start out with saying this. I kind of want to start out from this standpoint. Conservative relentless assault on affirmative action. Conservatives have basically twisted the meaning of race neutral jurisprudence. Jurisprudence is just a big word for court decisions. Race neutral court decisions to argue that using race to redress racism against blacks discriminates against whites. That is, they call it reverse discrimination. So let me make sure I said that correctly. Let me make sure folks understand what I'm saying. I'm saying here that under this race neutral thing, and this is a big issue with critical race theory, under this so-called race neutral, that is not taking race in account when formulating policies and when making, when doing things like voting laws or deciding what voting districts there are. Those things are supposedly done from a race neutral perspective. And conservatives, though, have twisted that to say that if you now use race, even to redress the discrimination that blacks have suffered and continue to suffer, then you're discriminating against whites. And in these cases, in these cases that we're going to look at today, even against other minorities, Asians specifically. So the question today is it unconstitutional? Is it immoral? Is it reverse discrimination? Is it counterproductive or unscriptural for a university to use race as one admission factor to redress the nation's historical and current systemic racism or to achieve diversity? That's what this is all about. And so with that said, let me now go back to the beginning of this whole matter, and let's start with the very birth of affirmative action. Now, affirmative action is a set of procedures designed to eliminate unlawful discrimination among applicants, to remedy the results of such prior discrimination, and to prevent such discrimination in the future. So first of all, what is so big and bad about that? I mean, that's what it is, as defined by Cornell Law School. I don't see anything that's really bad about that. A set of procedures designed to eliminate discrimination, to remedy such prior discrimination, and to prevent future discrimination. That's all it is. And the reason President Kennedy's face is here, Chloe, is because he is the person or the president who first mandated affirmative action. In 1961, that's even before my time, President John F. Kennedy issued Executive Order 10965, which said in pertinent part that government contractors had to take affirmative action to ensure that applicants are employed, that employees are treated during employment without regard to their race, creed, color, or national origin. That was the beginning of affirmative action as we know it today. It was an executive order issued by President John F. Kennedy. Now, it wasn't long after that that conservatives began to attack that policy, that executive order. And it reached the U.S. Supreme Court in a case, very, very important case, called the Regents of University of California versus Bakke. And in that case, Justice Lewis Powell, and I'm not going to get into a whole lot of the case, just the important part. But in that case, Justice Lewis Powell, writing for a 5-4 majority, said that yes, if race is being used to create a rigid use of racial quotas, then the Texas University, the University of California had indeed violated the Equal Protection Clause of the 14th Amendment. But if the use of race is being used to achieve a certain compelling interest, then it's okay. It's okay to use race as one factor, not the sole factor, but as one factor to achieve a compelling state interest. That's what the Bakke case held. The Bakke case said that when the government wants to use race, the government has to be very, very careful. In fact, the court said the government has to pass what we in the law call strict scrutiny, because race has been such a derogatory use in our country that before the government can use race to affect policy, to do anything, that law has to be strictly scrutinized, basically. So the Bakke court then applied the strict scrutiny standard to the University of California at Bakke. At California, the University of California in the Bakke case, they applied the strict scrutiny standard and essentially found that their use of race did not violate the 14th Amendment because they had a compelling state interest, which was and continues to be diversity. So the University of California said that we're taking race in consideration because we think it is very important that we have a diverse student body. And we can't have a diverse student body without taking race in consideration as one of the factors. And so the court said through Justice Powell, using race for that narrowly tailored purpose is acceptable. Okay? That is a compelling state interest. It is important, the court said, basically, that universities have diverse student bodies. So they said, although we don't like the use of race, we will permit the use of race with affirmative action programs regarding education because we believe it is a compelling reason to have a diverse student body. So that's what the Bakke case held, and the Bakke case became precedent in this area. So that was the law of the land. Affirmative action in education, in other areas, too, was acceptable so long as there was a compelling state interest, i.e., diversity in the student body. That was the law of the land. But conservatives, yes.
Let me just point this out, Dad, and just bring up. So, with the Bakke case, the Supreme Court ruled that universities could not use quotas, so could not say, okay, we want 1,000 Black students, we want 500 Asian students, etc.
That's right.
But the colleges could use race as just another factor when deciding whether to admit a potential student.
So long as it was intended to achieve a diverse student body.
So the Supreme Court since 78 has said you can't use quotas. You can use race as a factor as long as it was to achieve diversity, because the Supreme Court felt that diversity was good for society and good for the students, etc.
Exactly.
And that has been the legal precedent of affirmative action 78. Now, there's been various cases that you're going to get to that have been litigated since then, but that has been the prevailing legal standard when it comes to affirmative action in college admissions.
That's right. That's been the precedent. Thank you for making sure that that was clear. I'm trying to explain some pretty complex legal doctrine and standards in as simplified of a way as possible. But yes, that is right. That's been the law now for many years, since 1978. Affirmative action has survived attack after attack after attack because the highest court of the land said, yes, achieving student diversity on college campuses is good for the country. It's good for the student bodies. It's good for the university. It's a good thing. It's a compelling state interest. And it's so long as race is, so long as the use of race also is narrowly tailored. Mm-hmm. And that's accomplished by using race as not the dominant factor, okay, not the major factor, not the only factor, but one of the factors, okay? Other factors, look at legacy, look at athletics, whether they are coming to play sports, whether they are children of alumni, whether they are from certain geographical areas, a host of different factors that these universities look at, and race is just one to achieve diversity. Okay, so that's the law of the land. That's the precedent. And pursuant to something in the law we call stare decisis, the U.S. Supreme Court usually will follow that precedent. Okay, now, so another case came up some years later because, again, this has been a relentless attack on affirmative action by conservatives. And that case is Grutter versus Bollinger. It's a case having to do with the University of Michigan's law school and whether or not their use of race to achieve diversity, whether that violated the Equal Protection Clause of the U.S. Constitution, of the 14th Amendment. And the court said, no, it does not violate the 14th Amendment. This opinion was written by the late Justice Sandra Day O'Connor, and in a 5-4 decision, Justice O'Connor wrote that the University of Michigan's law school use of race to achieve student diversity was a compelling state interest that passed strict scrutiny. So affirmative action survived yet another attack by conservatives. And Chloe, we just got to continue to stress that race is not the only factor. Race is not the major factor. It is but one factor. And when you compare that factor to all the advantages that white students have, right? And all the disadvantages that black students bring to the table because of a legacy of systemic racism and white supremacy and slavery and Jim Crow, all the things that the black community has come through, just using race to see if an otherwise qualified student can benefit the university student body, a qualified minority student who is otherwise qualified. Let's make that clear. So we're not talking about taking students who have less qualifications than some of the other students. But the school says that basically GPA, LSAT, or SAT, ACT are not the only criteria that we want to look at. We want to look at other factors, race being one of them, to see if that will enhance the educational environment and experience of everyone. So in Grutter v. Bollinger, the late Justice Sandra Day O'Connor said yes. The court upheld affirmative action, yet another attack. But here he comes, Edward Bloom and Students for Fair Admissions. And like you said, he goes out and he hunts out plaintiffs. He bankrolls these cases. He puts these cases together so that they can end up on the desk of the U.S. Supreme Court so that he can try to accomplish his goal of completely destroying affirmative action. And the next case that he helped sponsor, as you pointed out earlier, is the Fisher versus UT Austin. And yet, once again, let me find that case. Once again, the United States Supreme Court said that race is acceptable to produce a diverse student body so long as there's no racial quota, so long as it is one of the factors, not a major factor, not the sole factor, it is okay. And in this case, Justice Anthony Kennedy wrote this deciding opinion. And once again, the court said, following Bakke, because again, that's the precedent, that diversity is a compelling state interest. And again, so long as it's just one of the factors. So again, Mr. Bloom was defeated. All
And
right.
you know what's so interesting about that case? Um, I went to UT Austin for 2 years, and I got into UT because it had a policy where it would accept the top 10% of high school students, and I was in the top 10%. I applied, I automatically got in. What happened with Abigail Fisher is that she was not in the top 10% of her class. I believe her GPA was a 3.5 something. And so for students who apply who are not in the top 10% of their class, that's where they use these other factors. And so she was not admitted when UT used the other factors outside of that policy based on her grades and the merit.
Thank you for bringing this up, Chloe. I remember I forgot that Texas had implemented that policy, that top 10% policy, right? And it was how you got admitted to UT Austin. And I'm gonna let you finish your thought, but if I remember correctly, if you graduated high school in the top 10% of your class, you could go to any Texas state school that you wanted, right?
I believe that's correct.
Yeah.
And in fact, UT Austin's their income in freshman class, 92% of the income in freshman class were Texas students who were in the top 10% of their high school high school body. So, Abigail Fisher likely would not have been admitted to UT Austin, one, because she didn't fit into that policy. And then when they looked at her merit and her grades, she likely would not have been admitted anyway. So then to come back and for Edward Bloom to then recruit her and make her the face of his anti affirmative action parade that he's done is very disingenuous. And in fact, now she's helping to run his organization, her and her father. So he goes around, he puts students, he makes them the face of his own personal agenda, which is his anti-affirmative action agenda, and then he lobbies and he pays for it. And now he's doing it with Asian American students because the plaintiffs in these two cases that the Supreme Court will hear are majority Asian Americans. And so it comes down to a question of, okay, like, he wasn't being successful when he was putting white students to go against affirmative action. So let's put Asians, let's put minorities against minorities to get to the ultimate goal of affirmative action no longer being the lay of the land. So that's a little bit more context I wanted to add to.
No, excellent. I'm so glad that you mentioned that top 10% policy that Texas implemented um, to, in fact, to try to, decrease some of the complaints about affirmative action. And so one of the things that a lot of whites will do is try and shame black people by saying you wouldn't be here if it wasn't for affirmative action.
Yeah.
You wouldn't be qualified to be here. You took the seat or the place of a qualified white, and now Asians have joined that fight, that bogus argument. And again, here in Texas, it is absolutely not true when that policy was in effect, because you if you graduated at the top 10% of your class, then you was qualified as any other student. And just this morning, I read that Senator Wicker from Mississippi had the gall to say that any black woman nominated for the U.S. Supreme Court is a beneficiary of affirmative action.
Mm.
I couldn't believe. Well, no, I no, absolutely. Let me take that back. I absolutely believe he said that, because this has been their playbook. But the thing I want to point out is Senator Wicker has been the beneficiary of white supremacy, systemic racism, white male hegemony that has been going on for 400 years in this country. White privilege and all the rest. Okay? He didn't get where he got based on merit. He didn't get what he got based on his hard work. There is some built-in privilege from being a white male in the United States of America. And there is some built-in disadvantage in being an African American. So if a university or if an employer wants to use race as one of the factors to create a diverse workforce or diverse student body, and then some white person try and shame us? Are you kidding, Senator Wicker? And one last thing. Every one of the women who are being considered for the U.S. Supreme Court are eminently qualified. I mean, eminently qualified. They are second to none, to no one. So when they try and shame us, like you wouldn't be here if it wasn't for affirmative action, I don't care about them saying that. Okay? I don't think, some blacks believe that affirmative action should be gutted for that reason, because it gives whites the opportunity to question our, whether we belong in certain spaces. Okay? That's crazy to me, because, again, I question whether they belong in certain spaces. I mean, look, this country was built on the backs of black people. This country, the landmass was stolen from Native Americans. And so I will not be lectured by the people who did that, who enslaved blacks for 250 years and stole this land. And I will not be lectured by them about who is getting a free handout.
You're right. They didn't get it. Not only did they get a free handout, they took it, and they took it unfairly. And they took resources from this land, from the African continent, from the Asian continent, and etc. To get to where they're at now. But what I think also, Dad, I want to, as you continue down your what you're discussing, I also want to narrow it down to Asian American students, because that's what these two lawsuits that the Supreme Court are going to be hearing.
Well, your
And
mom just posted, she just made a comment. She said, from her understanding, I don't know what you're about to say, but from her understanding, 70% of Asians support affirmative action. And some say that Edward Blum is using the Asian community to pit them against African Americans. I believe that that is true. I believe that Asian Americans, I believe let me put it this way. I don't believe Edward Blum is interested in Asian students. I believe Asian Blum is using Asian students to gut affirmative action for the benefit of white people. Okay, not for the benefit of Asians, but for the benefit of whites. That's what I think. So I think your mom's comment is right on target.
I agree, but there is a louder majority of Asian Americans, Asian organizations that are coming out and saying that they are being discriminated against just because they do well on tests. They focus on education, and one opponent to affirmative action I was reading, and in this petition they point out that Harvard College, they use race as a basis for admissions. They also use leadership capabilities. They use and other factors like that. And they claim that when the admissions recruiters rate Asian American applicants, they tend to say that, well, Asians, they don't have a good leadership capability, so we're not going to rank them high on that, or they don't rank highly on other subjective factors. And so it knocks out the Asian applicant who has the highest SAT scores, perfect GPAs, but because they don't rank high on the other factors that Harvard College purportedly uses, that then becomes discrimination against those Asian students. And so that's kind of where the back and forth has been about in the chatter that I've seen online. I mean, even the litigation that's been pending since 2014.
Well, my response to that would be that out of all the groups in this country, some will call this victimology. They can call it what they want to call it. Out of all the various groups in this country, whites, Asians, Latinos, blacks, we're the only group that was literally chattel property and enslaved for over 200 years, and then dealt with another 100 years of Jim Crow, and has since then dealt with systems of racism and discrimination, and still do. And that has resulted, for example, in black families having 8 times less wealth than white families. That has resulted in mass incarceration. That has resulted in poor educational institutions, poor schools, public schools in black communities. We have been fighting for equality in this country, and that fight continues ever since we've been here. And so when they abolished slavery, Lincoln said, hey, we're going to start the newly freed enslaved people off with 40 acres and 2 mules so that they can get on their feet and get a fresh start. That was blocked after he was assassinated. I'm from the South. I'm from North Carolina originally. I grew up around farms. I can remember as a teenager many, many, many black farmers. Through discrimination, there's virtually no black farmland today. I could go on and on and on and on with the type of discrimination that we as African Americans have suffered and continue to suffer. And for a university, in light of all of that legacy of racism, to say we're going to look at race as one factor in whether we want to admit an otherwise qualified student. I see nothing wrong with that at all. It's not only is it not wrong, I tell you what, let me put it this way. If you want to get rid of affirmative action, then give us reparations. Give us reparations for all that we've suffered. Give us the $1 to $2 trillion that you have stolen from us over the years. Give us that. Give us that. And then take your affirmative action.
Sounds like we need to make this we need to bring back a segment that we used to do where we would debate.
You're talking
Not
about
used
the
to do,
verdict.
just- yeah.
What will we debate about?
Whether or not affirmative action is racist to whites and Asians.
I don't believe it is. Do you believe it is?
I don't, but I can argue either side.
You know, I could too, but this is so consequential that you know what? I don't even want to do that in this instance. Because, you know, both of us, we know that it's not. We know that it's not reverse discrimination. Besides, these people still control the country anyway. And you're upset that a black woman may end up on the U.S. Supreme Court? Or you're upset that, and by the way, I didn't fix a slide for it. But even at Harvard over the last 7 to 8 years, Chloe, blacks still only made up about 10, 11, 12% of the student body, which is right there with what our population is in the country. So we still haven't gotten some unfair advantage. I mean, let me just end my segment by saying Mr. Bloom is likely this time to succeed because of these people. All right. As you said in the beginning, conservatives now have a 6-3 supermajority. And John Roberts, we know he is very antagonistic toward affirmative action. Clarence Thomas as well, Sam Alito as well, and Kavanaugh, Gorsuch, and Coney Barrett. They're all antagonistic and can't wait. That's why they took these cases. That's why they took these cases in the first place, because they've been waiting to get their chops on on affirmative action so that they can completely gut it. They'd already basically put it in a coma a few years ago, okay, with respect to employment. We won't get into that today. So it's been hanging, affirmative action has been hanging by a thread anyway. Well, they're ready now to cut that thread and completely kill this thing. And I am certain that it will die. Affirmative action will die this time for good because of these people right here. 6 of these people, no question about it.
Yeah. I agree. And I agree that affirmative action is necessary when you look at the history of this country and the history of racism, discrimination, terror, and trauma that Black Americans have played. Now, when I look at it from the eyes of Asian Americans, I think it does get a little bit more complex and gray versus white Americans, and this is the reason why.
Okay. So you want to do the verdict?
No, we don't have to.
I mean, we can if you want to sort of present the side as you understand the Asian argument on this. We can do the verdict. Let's do it.
Well, I haven't formulated any arguments. I was just going to bring just a little nuance when it comes to the Asian American applicants.
Okay, well, do it. let's do it right here with the verdict. What about that?
Sure.
Go.
May it please the court, honorable justices, opposing counsel. My name is Chloe Corbett. I am one of the attorneys that represents Students for Fair Admissions, and we represent thousands of applicants and plaintiffs in this matter. This country was founded on the belief that anyone who comes here can be successful. And it was founded on the belief that the American dream, if you work hard, is attainable. Now, we know that even though that was the ideal of the founding fathers and the Constitution, that we didn't get it right. Slavery is a dark stain in this country. Racism is a dark stain in this country. Treating African Americans differently and other minority groups is a stain of this country. And we have worked hard over the course of our relatively young history to counteract and to counterbalance the what we put on minorities. But we represent a group of minorities, Asian American applicants, who have worked hard, who have pulled themselves up by their bootstraps, who have worked to attain the American dream, who saw something brighter when they came here, and they have contributed a lot to our country. And because of their focus on education and because of their focus on making sure that, even though um they came here with not a lot of money, but that their children will be focused on education and working towards that American dreams. These plaintiffs should not be discriminated against just because they do well in school and they put a premium on education. So we believe that affirmative action is reverse discrimination against Asian Americans and against white Americans. We believe that colleges should only consider the merit of a applicant, that colleges should only consider, you know, um, the educational standards of an applicant, not the race. If we want to work towards a more just and equal society, then everyone should be judged by their hard work, by their merit, and not by their skin color. So we are asking that the Supreme Court will order that Harvard College cannot use race as a basis of admissions of its students. We ask that the Supreme Court will hold that the University of North Carolina cannot use race, and that every person who is admitted to these colleges are admitted based on their merit and nothing else. Thank you.
Well, Judge, may it please the court and to counsel, I have two very simple things to say. Asians weren't enslaved for over 2 centuries and chattel property, and were lynched and raped and brutalized and murdered again for 2 centuries, 2 centuries. And then once the enslavement ended, then still had to fight, as African Americans have, another 150 years of Jim Crow, of systemic racism, white backlash. Every time it seems as if African Americans make any little progress, here comes a group of white people to try and undermine that progress, to stop that progress. Also, Asians have benefited from the struggle of the African American community. It has been the African American community who has fought racism and xenophobia and discrimination, and oftentimes it has been other minorities, including Asians, who have tremendously benefited from our struggle. And and we do and will not allow this case or anyone to cause a division between African Americans and Asian Americans at all. Um, but we do believe it's disingenuous for this organization to make the argument that by taking race as one factor to achieve a diverse student body is somehow discriminating against Asians, again, with the advantages that they bring to the table. Many of them come from countries where there was not discrimination, racial discrimination, because though they come from homogeneous societies. Whereas Black Americans have been here once again just catching hell ever since we've been here. And when counsel says that the Asian community has pulled itself up by its bootstrap, again, we take nothing from the Asian community. We admire the Asian community, certain things about their culture. We have those things as well, but we have been the victims of unprecedented oppression. And so we too would pull ourselves up by our bootstraps, but the boots and straps were never given to us. We were supposed to get 40 acres and 2 mules, but they didn't do that either, and reneged on every other promise that has been made. So we would ask the court to reject that argument that Asian Americans are being discriminated against because of affirmative action. We would argue that affirmative action has greatly benefited the Asian community. They're getting consideration as minorities that we have fought for them to get and for all other minorities to get. So we would ask you to deny that. All right. Thank you for doing that. Yeah, I mean, I think you basically, I read the complaint in the Harvard case and Harvard's reply, Harvard's brief back, and it's not complicated. This is a simple matter. They're asking the court to overturn Bakke, to overturn Grutter, and basically say that diversity is no longer a compelling state interest, and because Asian Americans are being discriminated against. And I'm not going to allow this to cause me to become have animus toward the Asian community. I'm not. This guy here is using minorities to try and get minorities fighting one another. And I'm glad to know that most minorities do not agree with that. And I appreciate the nuance that you're trying to bring out, Chloe, where Asians are concerned. Okay, I'm not discrediting that either. I don't know if you finished bringing that nuance out. Did you?
I did, and I want to make it clear that I believe diversity in college is important. I believe that there is a benefit for the country to have diverse student populations. I believe that using race as a factor in considering students, I see nothing wrong with that. I believe that affirmative action is necessary because there are still so many effects of racism and systemic racism that still affect the Black community to this day, and there has not been a true reckoning um, for for the systemic racism in this country. And until we have that reckoning, that's what affirmative action is there for, to provide these protections. And I don't know if we'll ever have that reckoning. And so there needs to be protection from the federal government, from the Supreme Court for Black people in this country, because the trauma that we are facing and have faced being brought over here as chattel property, we are still feeling today over 300 something years later. And it has not been rectified. There has not been a coming to Jesus moment that this country has had to truly rectify the fact that 13% of the population are the descendants of people who were not even considered human, are the descendants of people who suffered from sexual assault, are the descendants of people who were violently and tragically taken away and with their families, and now are disproportionately shot and killed by the government. And I say the government for a reason, because the government gives authority to these police officers when they shoot and kill Black men. So yes, I do truly believe that affirmative action is necessary, and I believe that diversity um, is a is critical is critical for this country. So I hope that the Supreme Court does not overturn Grutter and Baki, and will continue to allow these
But
universities to use race as a factor, not the only factor.
we know they are going to do it.
Yeah, we know they are, because there's a 60 majority, and that just shows that our votes matter. You know, Trump was in office one term. He appointed 3 Supreme Court justices. That has completely changed the tide of the Supreme Court in a lot of issues in this country that will reverberate for decades to come.
And by the
So
way,
your vote matters.
not one of his nominees to the appeals court, the federal appeals court, not one of them was Black. Not one of
And
them.
most of them were the ones that were actually unqualified.
Exactly. Now, exactly right. Talking about affirmative action, this or that. Exactly.
Yeah.
So that's why Senator Wicker's comment means nothing to me. Now, as we come to a close, I do want to go back to this broader question of whether it is wrong to use race to redress Blacks, the situation that Blacks have faced. Is it wrong to use race to redress that wrong, even if it causes some disadvantages to other races? That's the broader question here.
Yeah.
Especially in a country that, tries to pride itself on race neutral laws. You hear white conservatives using Dr. King's "I Have a Dream" speech, where he said he dreamed for a day where his children would not be judged by the color of their skin, but by the content of their character. And they take that to say, okay, that therefore means that the country should be colorblind. So, in other words, not only should nothing be done against Blacks, but nothing should be done for Blacks as well.
Well, I think we need to bring in the fact that affirmative action, a large a large part of that policy was to help Black Americans, but it was also to help women. It was also to help other minorities. So it's not just saying, okay, we're going to try to use, the race of an African American student or, potential employee. It is to help. It could be used to help Asian Americans as well, or women. So I think it's unfair to just say, well, you know what, affirmative action is just for Black people, and Asian Americans are being hurt. I think you have to go back to the history of what affirmative action is and who it actually benefits. And a lot of times it benefits women, white women, women of all races,
That's why you
other
getting. That's
minorities.
why you getting the applause right there, because of the benefit that affirmative action has done has had for white women.
Yeah, but before we get off, I want to address this again, Dad, because you brought it up. It's not saying that unqualified applicants to colleges, black applicants, should be admitted. And that is just a false narrative that is being put into society. That just because you're black and you go to Harvard or you are an attorney or a doctor, you are unqualified. I hate that. And it is a what's the word? A contamination of what affirmative action was really supposed to do, which is just to put everyone on the same playing field as much as possible.
Well, I want to. There's a comment here by Navi. I think this. Commenter is a first-time commenter on our channel, and welcome. He or she says, "I got mixed opinions on affirmative action. I feel that it helps, but I worry that the helping hand might be ultimately harmful." Now, um, that sounds like the argument I hear a lot coming from some African Americans. I don't know the race of Navi, and I'm not going to presume.
She said her name's Nuvi.
Nuvi.
Yeah.
Okay, sorry, Nuvi.
Hey,
All right now.
thank you for being sub for a few months. We appreciate it.
Okay, so Nuvi, I'm not certain. Okay, Nuvi says she's Hispanic, or he's Hispanic. Um, all right, so a lot of African Americans really make that argument, though. It's like, okay, if they kind of see affirmative action as a handout, right? It's going to cause some African Americans to not really do their best or give their best, to work hard, to achieve and to earn what they get, because they can always fall back on affirmative action, sort of a handout. And I'm glad Nuvi asked this question or made this comment, because that absolutely is not what affirmative action does. Once again, the purpose or the reason affirmative action has survived the last 50 years or so, since 78, however long that is, was that 44 years or 54? Which one is that? 44 years? The reason it has survived is because it was intended to, again, increase diversity on college campuses. And that was not by admitting unqualified students. It was by admitting otherwise qualified students who happened to be African American. And the student and the universities say, hey, our university experience is better with African Americans on campus. Okay? So we do want to consider African Americans like they do consider the children of alumni. They get even greater weight than the little weight given to race. All right? So affirmative action does not give a handout to people. Again, it just takes in consideration the importance of diversity, number one. And number two, it takes in consideration the legacy of systemic racism in this country.
Yeah, I think you addressed Nuvi's last point too, which is he said, I was thinking like when you feed wild animals, they forget or at least lean away from traditional means of getting food. So I think, like you said, we view affirmative action as not being a handout to people, as not saying, you know what, you can't work hard. We're just going to give you everything, and you can't pull yourself up by your bootstraps. but it's just a way for you to get your foot in the door. And I think that addresses Nuvi's last point. Because we, look, that you and mom taught me that to get where I got to get, I have to work hard.
Harder.
Y'all were
No, not just
on,
hard.
no, you're right. You're right. I'm sorry. Harder. You have to be better. You have to be better than your white colleagues and your white students. And so, ever since me and Caleb were
I
young,
mean, you
it was
you I mean, you got to be you're right. You got to be exceptional.
exceptional.
Exceptional. You got to be 2 or 3 levels above your white counterparts because you're
Yes.
going to lose 1 or 2 levels just being black. So you got to be above them so that when you lose that 1 or 2, you're still better than them. But go ahead.
Yeah. So you had us, we were not able to watch TV in middle school, you and mom. Up until high school, we were not allowed to watch TV. We had to get all A's and B's. We had to read books. We had to, there was just a premium put on education and working hard. So we're not saying, our support of affirmative action is just saying we'll give black people a handout because they can't do it. They can't, be successful without it. Um, we don't focus on education. That's not what we're saying at all. But we recognize the history of this country and the way that systemic racism has put the black population as a whole. So I want to point that out.
Thank you
And
for
then,
saying thank you for saying
yeah,
that. Thank you for
yeah,
saying that. That was critical. That was critical because as hard as I push for affirmative action, thank you for bringing out that it is not because I want to see or we taught our children to expect a handout. No, you work hard. You study hard. We said, your mom and I, you all do not bring but nothing but A's in this house, B's occasionally. And you're right. No TV. When you get home, do your homework and then read. Okay? Forget the TV. All right? And as a result, you both graduated in the top 10% of your class. I think you in the top 5%. And you both graduated college, high up. So don't, thank you so much for bringing that out, Chloe. Not to bring attention to me, that ain't what this is about. But African Americans across the country, we already know how much better and superior we have to be. So we drill that in our children.
yeah,
We drilled that in our children. Don't judge us, all of us, based on what you see happening in some poverty-stricken neighborhoods. Those are good people too. Most of them are good people as well. But don't judge us just based on what you see on TV on the evening news. We know what it takes to just compete in this country. And it certainly is not going to come through affirmative action.
yep.
Okay?
So I want to go back to, there's a couple more comments we missed.
Okay.
Sean Breezy said maybe they should get rid of affirmative action because we don't benefit from it. Now I presumed he's saying we being African Americans.
Well, let's ask
That
him
is
let's ask Sean Breezy, what does he mean?
Yeah.
Yeah,
Yeah.
Sean Breezy, tell us what you mean so that we can be on the same page.
And then A Chief, what's up? I see him a lot on our videos. Thank you for watching again. But he said, I disagree, Chloe. It was only for blacks. Now, I think what he's saying here is when I brought out that affirmative action is a policy that was not only for black people, but um, for women as well as other minorities. So I think that, thank you for that comment, A Chief. I think that affirmative action, the policy of affirmative action from Reconstruction era, right after the Civil War, in trying to get African Americans reparations, the 40 acres and a mule. I think that was made specifically for black people, for descendants of slaves, and for newly freed slaves. But as affirmative, this policy of affirmative action percolated through the decades after the Civil War, it was used as a way to benefit women, and it was used as a way to benefit other minorities as well. So originally, maybe the policy of affirmative action before it was called affirmative action in the 1960s was solely for newly freed slaves and for African Americans, but it was used and it helped and it benefit a lot of women, a lot of white women,
Well,
and other minorities as well.
well, Chloe, Sean Breezy, seems like you all are saying the same thing. He said, I feel it benefits women and other minorities than us. So I don't, when he says I disagree, Chloe, sounds like he may have misunderstood you then.
Mm. Well, no, A Chief is the one that said he disagrees.
Oh, sorry. Okay, Sean,
Yeah.
okay. All right, thank you. And I do want to, Nuvi here said something I think that we should comment on. He said trade schools are a bit more important these days, in my opinion. But I am a diesel mechanic, so I may have bias. I actually agree with you, Nuvi. I a lot of the people, a lot of the folks in our country who are sort of secret millionaires are people who have small businesses, who are in business for themselves, or they have a trade of some sort. Let me give you an example. I'm an attorney. I never forget the time that my toilet backed up here at the house. I called a plumber. Chloe, he came and unstopped everything, and from the time he got out of his truck to the time he got back in, it was no more than about 10 minutes. And that cost me $150.
Yeah.
Okay? $150. That is equivalent to about $1,000 an hour.
Yep.
That was a plumber who probably learned how to be a plumber on the job or maybe a year or so in a trade school, and he's making that kind of money.
Mm-hmm.
So I actually agree, and all of that without student loans.
Ooh, yeah.
So I actually agree with that, Nuvi.
I do too. Trade schools are very important. And just like you said, a lot of the millionaires in this country are small business owners and people who provide services and trades and can price their services at whatever amount they want.
Okay, we got a new commenter. Stephen Perry says affirmative action hurts all people, even blacks. Mismatching is real. So I'm not going to read into Stephen Perry's comments. Maybe he can follow up and tell us how he believes affirmative action hurts all people, including blacks.
We have a few comments from Featherless. Is it what is this? What is the second? Do you see Featherless's comments?
Yes, I do. Let me just follow up with Stephen Perry. He said he wanted to know if I understood the story behind 40 acres in a mule. He said it wasn't trying to be rude, but do I know the story? Yes, I certainly do know the story behind 40 acres and 2 mules, actually. And so I certainly do. Bottom line is it was promised. It was promised to us pursuant to an executive order, 2 executive orders actually. And those executive orders were essentially overridden or repealed by Andrew Johnson, who became president after Lincoln was assassinated. The 40 acres and 2 mules was something that was being done by the Union Army. I forgot the general's name, but it never went into fruition again because Lincoln was assassinated. So yeah, I do know the backstory. All right, Chloe, who was the gentleman? Yes, let me, because we're coming to a close here.
Can you read Featherless's comments? The way I
Yes.
have my screen set up is kind of hard to read the comments.
All right. Featherless bite.
Is it biped?
Biped. Okay. I'm sorry. Sorry about that, Featherless. All right. So Featherless is good, he says. We talked before. We talked about rap in your book about your case. Okay. Okay. All right. Very good. Featherless. Let me see. Okay, so Stephen Perry here is what is dropping some knowledge here. He says it was a war order by Sherman. Yeah, Sherman was the name of the general I couldn't think of. During his march to the sea, but it wasn't for all slaves, just for the ones affected by the march. I don't know about that particular, but whether that nuance is correct or not, bottom line is no one got them. That's the bottom line, Stephen. That's the point I was making. Whoever it was intended for, they didn't get it. However, again, being from the South and growing up in the country as I did, still African Americans were able to work hard and save and buy a lot of farmland from the time that slavery ended up and through about the 1970s, 80s, when the U.S. Department of Agriculture essentially helped steal that land and helped transfer all that wealth to white farmers. I remember that vividly. All right, we're coming to a close, Chloe.
Featherless said that she is the white lady named Squid before. I remember her now. Um, and she said education is hard to get. The systems aren't working. They came from people that value education. I mean, that's true. Education is tough. It is hard to get. And I think Nuvi brought out a good point of how important trade schools are and having a service and pricing that service at whatever price point you have.
Yep. I'm going to go over to Facebook before we close and see if there are any comments over there. Sometimes we miss Facebook comments, and we want to get them all.
So y'all let us know if you have any more comments, any questions before we get off. Is affirmative action racist to whites and Asians? That's the question for today's video. We're going to be keeping a watch on these two Supreme Court cases that are going to be argued before the Supreme Court later this year, sometime in the fall, likely. Um, One of the biggest cases is the Students for Fair Admissions versus the President and Fellows of Harvard College. Again, the Students for Fair Admissions is an organization created by Edward Bloom, who is a conservative legal strategist who seeks out potential litigants and puts them in touch with attorneys. And he has been an anti-affirmative action opponent
And
for many
voting
many years.
rights. And
And
voting
voting
rights.
rights.
Yes.
And voting rights. Yes, he was the key reason why Shelby County versus Holder was put before the Supreme Court, and the Supreme Court struck down Section 4 of the Voting Rights Act, which said that the federal government basically couldn't can no longer scrutinize before states makes changes to their voting rights policies. So he has been a huge anti voting rights person as well as anti affirmative action. So these two cases are they're going to have effects on our country for a long time, and for the nature of college admissions for a long time as well. And because of that 6-3 conservative majority and the way that the Supreme Court, and just because when you were going through the cases, that if you notice, affirmative action was supported, but it was supported by a low majority. One opinion was 5-4, and the other one, I think both opinions were 5-4, I believe, in
Which one?
favor of I think Grutter was 5-4, wasn't it?
Grutter was 5-4. That's right.
Yeah. So I mean, just one justice made the difference in upholding affirmative action even back then.
And
And now
and
we have a
and
6-3 majority.
in the Seminole case, Bakke was also 5-4. It was all over the place. Quite frankly, Justice Lewis Powell agreed with the folks about the racial quota, but then he also agreed with the folks that race should be used to achieve diversity. What they were trying to do in that case was appease conservative whites or angry whites about affirmative action, while at the same time, saving it. And
Yeah.
isn't that always the situation here? That's what we're going through now. So, again, for me, the broader question still is whether or not it is acceptable to use race to redress racism, even if it disadvantages some other people. And I would say yes. I would say yes, because African Americans didn't get in this situation because in other words, we got in this situation because we were greatly disadvantaged. And so now if you got to if it's necessary to disadvantage some people by taking race in consideration, then so be it. So be it. So be it. That's not unfair. That's not unfair at all. This country, you said a moment ago, Chloe, that you don't know if this country will ever have the racial reckoning that it so needs.
Yeah.
That was disheartening to hear that, quite frankly. A young person to say that. A young African American person to basically say, I don't foresee my country ever really addressing or redressing the legacy of racism this country is known for. And I can understand that level of disillusionment, especially in light of Donald Trump and how the toxicity that he has introduced into this discourse about race. But I want to encourage you and other young African Americans who are listening to me, and other minorities, period. Don't give up. Make this country have this racial reckoning. You got to force it. That's what King did. That's what Frederick Douglass did. That's what Harriet Tubman did. You have to force it. You have to make it come to grips with its racist self and soul. You can't quit. You can't give up. You can't throw in the towel. You can't say, well, it's never going to happen. You have to make it happen. Coretta Scott King said, freedom is never really won. Each generation has to fight for it in its generation. So when you get a little disillusioned, remember the 5 young people that we represented who were out protesting for George Floyd. And remember all those young people, white, black, Asian, Latinos, who were in the streets demanding a racial reckoning. So it can happen. It will happen. It will happen.
Yes.
That's where I stand, because otherwise, if you younger people don't push it and make it happen, there is a crowd, there's a wind blowing now that is trying to turn it all back. All right. So
The young people are the future.
that's right. So that's going to do it. That is going to do it today. Thank you, all of you, for sharing with us today.
Before we get off, Nuvi said, have you guys considered reaching out to Natalie Lawyer Chick? She probably love to discuss this. I've never heard of Natalie Lawyer Chick, but I'm going to look into her and her channel. I'm definitely going to look into her. So thank you for that suggestion, Nuvi. And then Featherless said that these guys are great, referring to us. And she said they need to grow this channel. Lots of people would love to know this stuff. We're working on it. We're working to add into the community of Legal Rebels and getting this channel up here. But we love discussing this stuff with each other and with you all. And this is just a stress relief, to come up here Saturday and discuss pressing topics and to have these frank conversations is so good.
Yeah, I didn't see all these comments down here, but these are great comments. Thank you all for these comments. Fatherless Biped, race is a construct. I really, really wish we had time to get into that. I agree so much with that statement. Absolutely. And Blight Youth needs this. Fatherless Biped said, absolutely, you're right about that. Thank you for all of that. So we're at the point now where we, got to bring this to a close. We've enjoyed it tremendously. Chloe, you got the last words.
All right, guys. So we love the discussion. We hope you all got something out of this conversation today. We're going to be back next Saturday around 1:30 Central Time or 2 Central Time. And we're going to be discussing the most pressing topics. Thank you all again for tuning in, for listening to us. We hope you all have a blessed and wonderful Saturday and weekend. We'll see you next week. Y'all take it easy.
Bye-bye. Peace, love, soul.